Hi, everyone. My name is Nguyen, and a recipient of the Junior Monroe Scholar Research Grant provided by the Charles Center. My presentation is on Biden's judicial nominations of public defenders on case outcomes, supervised by Professor Christine Nemacheck. The trajectory of the federal judicial system has been influenced by shifting sociopolitical climates over time. Now, a notable shift came under President Biden when he aimed to nominate a significant number of public defenders to federal courts. This decision marked a departure from the norm, as historically, the federal judiciary was largely populated by individuals with either prosecutor or corporate legal backgrounds. By the time we reached March 20, 2023, Biden had already ensured the confirmation of 31 judicial candidates who previously served as public defenders. This is no trivial statistic. Public defenders, by the nature of their role, represent indigent defendants and have firsthand experience with the systemic biases that these individuals face. The role of demographic diversity in the judiciary, encompassing race, gender, and ethnicity, is undeniably vital, yet experiential diversity offers a richness of perspectives that can shape the legal landscape. After 4 years of President Trump's tenure, during which the federal court saw an influx of predominantly white male nominees, Biden's administration felt the need to recalibrate. And so Biden hoped that these judges, familiar with the struggles of indigent defendants, will reflect these experiences in their decisions. My research question is, how has the Biden administration's nomination of public defenders, specifically judges like Candice Jackson Akumi and Veronica S. Rossman, influenced the ideological trajectory and decision-making processes of appellate courts? And to what extent does this appointment strategy signify a shift from previous administrations? The study's primary objective is to explore the potential influence of Biden's nominations of public defenders on the liberal tilt of appellate courts. Jackson Akumi has been serving as an appellate judge for the Seventh Circuit since July 2021. Her professional history includes a decade-long service as a federal public defender in the Northern District of Illinois, where she advocated for over 400 clients. On the other hand, we have Rossman, who holds her position as a circuit judge on the 10th Circuit Court of Appeals and previously championed the rights of over 250 clients spanning both Colorado and Wyoming. The chosen cases exhibit characteristics that enable an evaluation of the judge's underlying legal strategies, their ideological leanings, and how their history as public defenders might intersect with their judicial roles. These two judges symbolize just a small fraction of the 140 confirmed appointments made by Biden as of mid-2023. Thus, while the study evaluates judges hailing from non-traditional backgrounds, it does not aim to be a comprehensive generalization. So for the purposes of this presentation, we're just going to focus on 2 of the 5 examined cases. In Andrew Dunleavy versus James Langfelder, Dunleavy, a white utility meter reader, alleged racial discrimination following his termination by the city of Springfield, and he juxtaposed this treatment against a Black coworker named Murray. The Seventh Circuit reversed the lower court's decision, favoring the city with a focus on the nature of disparate treatment and evaluation. Now, Jackson Akumi, author of the majority opinion, critiqued the district court's narrow comparative approach between Dunleavy and Murray. Her perspective offered a really broad lens, suggesting the presence of racial motivations behind Dunleavy's termination. A crucial point of interest here is Jackson Akumi's background as a former public defender. This experience undoubtedly colored her understanding of systemic biases and underscored the importance of a wider perspective over narrow job duty comparisons, demonstrating a commitment to upholding civil rights. Moving to National Nurses Organizing Committee versus Midwest Division, a conflict arose between a nurses union and Menorah Medical Center. Central to this dispute was the interpretation of their CBA in light of a new staffing plan. The 10th Circuit upheld the district court's favoring of the hospital, interpreting the issue as fundamentally about the staffing plan. But Rossman's dissent really stands out as a beacon of clarity. She posits that the union's grievance was fundamentally misunderstood by the majority, where instead the contention was deeply rooted in the displacement of bargaining unit work. Rossman was attuned to union's needs, which really underscores her understanding of the implications of legal decisions in the real world, rather than these black and white interpretations on paper. Both cases exemplify the impact of a judge's experiential background on their judicial interpretations. This case study has illuminated a marked shift of the Biden administration's methodology for judicial nominations. While diversity might be a term we hear really often, this administration appears to be broadening its understanding. Beyond just racial or gender consideration, there's this exciting emphasis on diverse professional backgrounds. While we cannot deny the enriching potential of a diverse bench, it's also ambitious to conclude that public defenders will uniformly tilt the appellate court in a liberal direction. And so to grasp this shift's implications, both on its merits and challenges, we must engage in continued dialogue. Thank you so much for listening to my Monroe research. I hope it's been really insightful, and subsequently attached are my research citations.